Good morning, good evening, good afternoon. Now it should be better. Good morning, good evening, good afternoon, wherever you are right now in the world. My name is Stefan Hopper. I'm the president of the OPC Foundation, and today it's a pleasure for me to welcome you to a new webinar. Today it's about a security topic, and it's a huge pleasure for me to welcome in a second Dr. Gerrit Hötzel. Just for your information, we already had a security-related event. It happened on June 5th, 6th, hosted by our board company Microsoft in Munich. This event was designed that security experts could get in touch to each other and talk to each other directly. This event was so successfully that we thought we need to provide this information to the world and share it with the world. The second really, for me, surprising point was that the audience obviously voted the highest valuable speaker after the event. And guess what? The first time in my 30-year engineering career, a legal person has been voted as the best, highest valuable speaker. It was Dr. Gerrit Hötzel. So we thought, why not start the webinar series about a lot of security topics related to the Cyber Resilience Act with him. And so it's a pleasure for us to have him today online. As you see, he is providing two different talks, two different topics right after each other. And as you also see, the interest of the audience is amazing. Within just a day, we had over 300 registered people. And status this morning, we have even over 600 registered people for this event. So there will be in overall two sessions. Session number one is about the commercial use of open source under the Cyber Resilience Act. And the second one is about 10 example cases for the Cyber Resilience Act contract design and supply chain management. After that, we will have Alexander Almendinger moderating a Q&A session. So please be interactive. Whenever you have a question, post your question into the Q&A window, and we will answer all the questions at the end of the seminar. I do not have to explain Dr. Gerrit Hötzel in detail, but as you see, I can't believe that he says he has over 15 years experience. He looks much younger. And as you see today here in a second, he is looking like more like a legal person. Today have a new environment here with a green screen. Normally it's blue, so I apologize for that a little bit. I will optimize next time. One of the most frequently asked questions is, are the slides and the recording shared later? And the clear answer is yes. Again, everything will be shared later. You will find it under the download here on the OPC Foundation web if you click under Resources, Material, Presentations. But with this, it's a pleasure for me to hand over to Dr. Gerrit Hötzel. And Gerrit, the floor is yours. We are listening to your presentation.
Thank you for having me. The picture is an old one that explains the 15 years. Thank you very much. We're going to talk about the Cyber Resilience Act today, and the Cyber Resilience Act in two instances. The first one is, how can we use open source software in a commercial setting under the Cyber Resilience Act? There are a lot of things to consider when it comes to the Cyber Resilience Act, and the open source software realm and the use of open source software is one of the bigger things here. That's why we have a focus on this in particular. So diving right into it, there are 4 different scenarios I want to distinguish here, and depending on which scenario you are in, you have to look at this a little bit differently. So running through them really quick, there is a first scenario where you are a single person when it comes to open source software. So this is one of the standard ideas and associations that you have as open source software. You're a single person or a single entity devoting your evening hours as a hobby, more or less, contributing to open source software, or maybe a little bit more in a professional setting. But in the end, here is more or less the hobbyist who does the good deed and provides some programming and some source code to the open source software world. In a second scenario, you are a non-profit organization contributing to the open source software realm. There are a lot of organizations. We have the OPC Foundation as a foundation. There are a lot of open source software organizations you are all aware about: Linux Foundation, Python Foundation, Apache Foundation, and so forth. Then there is another scenario that we have to distinguish. This one is actually a company, a company running a commercial enterprise, and they have employees working and being paid, working for the company, being paid by the company, and what they do from dusk till dawn, or the other way around, is to contribute back to the open source software community. Why do they do that? Well, to make on a factual basis some standardization to provide back, and if they, from their company point of view, provide the source code, it will be used by everyone, and on a factual basis, it will become a standard. Just one point to make here. There are a lot of other aspects as well. But the gist of it here is these are people being paid by commercial enterprises to contribute to open source software. And then there is, I would say, most of you in a fourth category. This is a company integrating and using open source software in your product. So just to make a quick example, if you're a manufacturer, you might have invented a super cooking machine, a Sukuma, which includes an embedded Linux environment. Just a very easy, simple example. It can be any embedded system here or any other system as well. But let's stick with this example. So you're having this Sukuma, this cooking machine, and it includes an embedded Linux environment. What does this mean? It means you have a Linux kernel somewhere in there. You have some basic Linux user space programs, and then of course you have your own applications in there, which again is something probably in the user space. Maybe you have your kernel module. Then you have programmed something in-house. Maybe you have subcontracted some programming work to other companies. So these are 4 different scenarios that we have to distinguish when we look at the open source software use throughout the talk today. And to help you understand where we are at with the Cyber Resilience Act and why the language is as it is today, we have to have a quick look at the history of the draft, which is very funny to me. We are having the Cyber Resilience Act. It's still not finalized. We're still having a draft. There is no final end version of the text yet. There are still dashes and blank spaces in the actual act. So we're expecting it to be finalized maybe in the upcoming month. Probably will still be as we know it right now, but it is a draft, and there's a history to the draft. And in a very early stage of the draft, open source software wasn't very much considered when the Cyber Resilience Act was drafted. And in the end, they had the first as a recital in the Cyber Resilience Act, the first sentence here: in order not to hamper innovation or research, free and open source software supplied outside the course of sorry, I'm having with my windows here. Commercial activity should not be covered by this regulation. So it shouldn't be covered by this regulation. This is very good for the first scenario here. For the single person entity, I'm going back one slide, for the programmer who does work in the evening. And it's just a hobby. He does it for the good deed, for whatever. He doesn't get money, he doesn't get paid. This is good for him. But what about the other actors that we just went over? Like, what about the non-profit organization or the foundations? They don't really do commercial activity. Maybe, we're not sure, depends on the exact definition. But considering that they also have employees which get paid, and they have big time donations as well, there could very well be commercial activity. So there was some kind of outcry, and the EU Commission, when drafting the Cyber Resilience Act, they listened, and in a first draft after that, they made this recital into an actual article, more or less saying the same, and they added some guidelines here, and then they defined what a fully decentralized development model is. You have a single organization here and a commercial activity, and define what open source software is and when it falls under this. And this was better, but still not good enough, because now the outcry, I'm going back one slide, now the outcry was from the nonprofit organizations, because saying, well, we still not, we don't really see it, considering our donations that we get and other things. So not killing the evening contributor to open source software is nice, but not killing the nonprofit organizations would also be very good. And there was a further outcry by these, I'm going back one slide, by this company contributing to the open source software world. They also had a big outcry, like, why should we not contribute? We're doing this, we're paying our employees, they contribute to the open source software. Why should we have to adhere to the Cyber Resilience Act? And what this means, if you're actually falling under the scope, is that you, as a contributor to open source software, being it as a single person hobbyist, being it as a nonprofit organization, being as an enterprise who has an employee who gives back to the open source software realm, means that you have to adhere to the full Cyber Resilience Act with everything that's in there, in the end having a CE marking on your software product. And this doesn't really make sense in the open source software realm. So you have a current draft, and this is the language in there right now. It's very quick, and it's within the definition of making available on the market, which is actually more or less the standard definition, saying making available on the market means different things, and in the course of a commercial activity, whether in return for payment or free of charge. But the main thing here, and the main takeaway, is it is only making available on the market if it's in the course of a commercial activity. And this leaves a lot of questions if you don't know the history, but there's also a very long recital number 18 right now. And I won't go over everything here right now, but in the end, it's very clear that the first three animals are safe. The evening programmer is safe, the nonprofit organization is safe, and the commercial entities who have employees giving back to the open source software realm, they are kind of safe. They emphasize here again, just to go over it very quickly, that it is only in the scope of the Cyber Resilience Act if it is in the course of a commercial activity. And then you have the not-for-profit organizations, as it's actually called in the Cyber Resilience Act. These are the non-profit organizations. They should not be considered to be a commercial activity. This is very nice. It's very nice when you read it, by the way. I myself am a lawyer, so I'm the one who is actually, whose profession is to question what the text says and what the EU Commission says it should be. And I actually have to look at the text and see what it says and what it means, not what it should mean. And for me, it's very important that it's a recital. Recital is legally non-binding. It's just saying what the intent was when drafting the articles, which are in the Cyber Resilience Act later on. So here, a recital, for me, it's very nice to have, but for me, it would be even better if you have an actual article being legally binding and saying not-for-profit organizations do not fall under the Cyber Resilience Act. But, well, we take what we get, and it's pretty awesome already that we have this clarification here. So non-profit organizations are okay. And if you contribute source code, that it doesn't fall under this Cyber Resilience Act either. So the first three here are more or less safe, and they're very content right now. Again, the evening programmer, the non-profit organizations, and the companies giving back to the open source software realm. But who is not safe? Who hasn't been considered yet, really? That's actually you, or most of you, I guess, today who are attending here. This is the category number 4, everyone using the open source software. Now, what happened? We had a first draft where more or less open source software was covered under the Cyber Resilience Act. And the open source contributors would have to adhere to the Cyber Resilience Act, namely affixing the CE marking on their open source software. This would kill the open source software world because the evening programmer at least probably wouldn't have the money and the time and doesn't want to have the put in the effort to have all of this. But what happened now? These are out of scope now, but the end result cannot be that we have open source software integrated in all the products and there's no cyber resilience for open source software. That doesn't make any sense if you want to have cyber safe products. So all the obligations are shifting now to the companies and to the company first using open source software in a commercial setting. So if you are a company, in our example here, the manufacturer of the cooking machine, if you're the company including open source software in a commercial setting, which it is here the case, you want to sell the cooking machine. So you have to adhere to the Cyber Resilience Act and have to affix the CE marking on your product and declare conformity regarding the open source software that you included. In the end, it's good for cybersecurity, but in my view, this is a tremendous task, and I don't know how this will all play out at the moment, to be honest. Because just look at my examples here. If you have an embedded Linux environment, then you have a Linux kernel. Just declaring conformity regarding the Linux kernel for you as a company, depending on your size, but even if you're a big company, is somewhat of a task, I guess. There might be simpler applications where you're just using one open source library, and this might be easier, of course, but as of now, you're more or less using open source without much consideration, usually, other than licensing ideas and maybe also some voluntary cyber security considerations. But otherwise, you can just integrate open source software. It doesn't even cost you. But now, if you have to declare conformity to all these open source libraries, open source tools, that's a tremendous task that you have there. So how will all this play out? No one is really that sure how it will play out, and there are some considerations here. And I've given you here some feedback from the open source software world and what they are expecting and what I think is likely to be expected. Again, these are things that this is not in the Cyber Resilience Act. The task is up to everyone to solve this issue that now the commercial enterprise first using the open source software has to adhere to the Cyber Resilience Act regarding the open source software. So the idea here is, what might happen is that the whole open source ecosystem might change. In the following way. This is just like one way that might play out in this direction. And what might be changed? It might be changed that the companies using open source software for the first time and integrating out open source software in their product for the first time, that they contribute back to the open source software realm with money. And so they provide some funding to the open source software projects so that they can make their software cyber resilient ready, more or less. This would make sense. It would make tremendous sense from the standpoint of keeping up the whole system, because if every company using the Linux kernel, for example, the first time in their product as a first commercial user, then every single company would need to do the same work of making or declaring conformity of the Linux kernel for their product. It would be much nicer if there was a more or less ready-made declaration of conformity for the Linux kernel or for any other open source software out there. So one thing that might happen is that they get more funding from hopefully you, they say, as a commercial users, so that they can prepare everything, and maybe there's some funding elsewhere as well. And some noteworthy foundations, they're very well aware of this issue, and I just named but a few here at the bottom of the slide, and they say they're up to the task, and they will implement support, and they will establish common specification to make it as easy as possible to use these open source software tools in the future as well. But I think this new ecosystem, or the change in the ecosystem, this needs to happen, and I don't know how it will get done. In the end, I think it's partly a task of the commercial enterprises to contact the open source software project that they are using in their products and see how this will how their setup is, and how they will be able to provide all the support and maybe even the pre-work regarding the Cyber Resilience Act in the future. There are some, I think the distributions, like the Linux distributions, for example, they will also maybe have a new task by providing more or less a packaging system, and maybe even in addition to the package maintaining process, an additional layer of compliance maybe. This is all something that would need to change, but it needs to change fast, because the transitional period, as we will hear later on, it's 3 years in the end, when it comes into force in a few months, hopefully. I want to touch some further aspects regarding open source software. And there is an Article 32 in the Cyber Resilience Act, one of many others, of course, and they actually set the ground for what I just laid out and indicated that what's possible. So with this Article 32, they address free and open source software, and they shall be able to demonstrate conformity when there is a technical documentation provided, and this technical documentation is made available to the public. So having a technical documentation is a bigger task if you have to declare conformity. Usually it's if you're not too familiar with the new legislative framework and the product conformity assessment rules, the technical documentation is some fundamental thing, but it's some work in there. But if it's a technical documentation provided by the open source software project and it's made available to the public, something which would very well be feasible for an open source project, like making it public, then you can kind of more easily integrate it into your product, because you can demonstrate conformity by more or less pointing to that public technical documentation. So this is a good thing, but the technical documentation needs to be there for you to be able to say, well, there it is. If it's not there, the responsibility is still yours as a commercial entity to declare conformity to all these things. Then there is a lot of ideas and thinking in the Cyber Resilience Act regarding open source software. But if you think about open source software and the adoption in a commercial setting, there are further aspects which haven't or don't seem to have been considered yet. Just to point out, one is the dual licensing, and this is something that came up also in the OPC Foundation summit in Munich this year. And this is a question of dual licensing. What is dual licensing? Dual licensing is if there is an open source contributor or an author, a copyright holder, and they say, well, we provide this tool as open source, and you choose a license like the GPL, for example. GPL is one of the standard classic open source licenses, but it's a red flag in every commercial enterprise because of the copyleft effect. I won't go into this, but in the end, GPL for most commercial enterprises is a red flag. They won't use it. So the open source authors know about this, and they say, okay, we're having a dual license. So my standard license is a GPL, for example, but if you want to use it in a commercial setting, you can pay me a small fee, and we have a commercial license, and I'm licensing it to you under a different license where you can use it way more easily in a commercial setting. And there is a small fee for the author also involved, which is very nice. But what does this mean? Is it now still open source software? The GPL part sure, it's very open source. But the dual licensing part, like the second part, where you have a commercial alternative license where a fee is paid, that's actually not so much open source anymore because there's commercial activity involved by that author. And this might pose a problem because, as far as I know, the fees being paid to the author are not that high that they all of a sudden have are enticed to do all the work for the Cyber Resilience Act and to declare conformity under the Cyber Resilience Act for their open source project and to fix the CE marking on their open source project. So what could that mean? That this, if it's a simple project, that the author of this simple project here would say, well, then I don't offer a commercial license anymore. This would be tremendous for a commercial enterprise because then they would need to switch to the GPL version, for example, here, which they, for some reason, because of the copyleft effect, don't want to use in the company. So this is very complicated, and for both sides, like what does a commercial enterprise do, and also for the author of the open source software, because, well, might they help solving the problem? Might they want to change from the GPL to another license like MIT, which is less problematic for the commercial enterprise? So there is nothing in the Cyber Resilience Act addressing this issue. This is something we have to deal with and to figure out in the future as well. This is something where we have to read the text closely, consider what is commercial activity, and also just figure out what each player here is willing to do. So, but for you, usually as a commercial enterprise, it's very important to see where is dual licensing in play. Where do you have a commercial open source license? They might not be there and around anymore in the future. I don't know. Some further aspects in the Cyber Resilience Act regarding open source software. First, I want to make you aware of a definition of open source software. I won't go over it here right now, but if you have a question, what is open source software? For example, in my case earlier, you can read now in Article 3, number 48. It's a very long one. So there is a definition of this, but sometimes you have to read all the definitions together, like making available there is the commercial activity, for example. Then what's new? What's also new is that the open source community is now a relevant stakeholder. This is what does this mean? If the EU Commission wants to do some surveys, they want to do some studies, they want to talk to someone, they're not talking, they're also talking to the open source community because they are a relevant stakeholder now. I don't know whom they will talk to because the open source community is, well, very widespread, but I think it's a good thing we have them here as a stakeholder. Another new thing here that you might have already heard or maybe not heard is the so-called open source steward. This is a new thing. And what this is in particular is also a bit open to how this is put in place in a real life and real world scenario. In the end, an open source steward is more or less the counter. It's one way of explaining it. It's a bit of a counterpart to the manufacturer using an open source project. And the open source steward is kind of someone who tries to steer the open source project in the right way regarding the Cyber Resilience Act. They have many tasks, but they have way less liability under the Cyber Resilience Act. This is a classic task, for example, for the nonprofit organizations, which are already aware of this new task, and they will, I think, make use of it and will steer this open source software realm hopefully into the right direction. And hopefully this shift to the new ecosystem, as I have called it, will help, will happen, and with the help of these open source stewards. If you want to read up more on this, there's an Article 24 just dedicated to the open source steward. One and two more things regarding this here is the Article 13. I want to point out to you, Article 13 is the main article in the Cyber Resilience Act regarding the obligations of the manufacturer. And here I want to point out subparagraph 5, which says if you are the commercial enterprise and you integrate components from the open source software, then you have to exercise due diligence. You are responsible for integrating this open source software. This is exactly what I've said all this talk, everything prior, but here you have it in black and white. Here it is: if you're the company integrating open source software as the first player in the chain, which actually uses open source software in the course of a commercial activity, then you have to exercise due diligence. You have to do all the work if it's not already done by the open source software project. To further help with the shift in the ecosystem, there's an Article 25 saying that there are security attestations of open source software. So this will help you with the due diligence that you have here, and there is the option of having these security attestations. How they're done, I'm not going to explain here, but just know there are and hopefully will be a lot of security attestations for this open source software project. If there are, you can kind of have less due diligence because you can already point to that third party who did the security attestation and saying, well, it's a safe product, more or less safe product. See here the security attestations. So I think all these security attestations will play a way bigger role in the future under the Cyber Resilience Act. And in particular, smaller open source software projects, they will maybe have to see if they join some bigger force where all this additional work can be done if they don't want to do it themselves. Because if you're just programming and just want to program and don't want to care about all this here, maybe this work can be done by some organization. One final thought here, concluding this talk here, is I'm going to touch this in my next talk as well, is that the Cyber Resilience Act itself does not include any regulation on a legal liability. There is a new draft for a product liability directive. The current directive is from 1985. There's a new draft. And in that draft, I want to point out here again, here you have it, the red text, again, more or less in the, and that's important, in the liability directive. They also point out as a main thing that if you are the manufacturer and you're the first one using a component in your product and the first user in the course of a commercial activity, then you are liable for all the damages caused by that product. And again, this is not in the Cyber Resilience Act anymore. This is in the draft for the upcoming Product Liability Directive. So even more stress on the fact that you as a manufacturer have to adhere to all these new stipulations. So let's make a small cut here. This was all the consideration I want to get across in half an hour regarding open source software. And let's look at some further aspects regarding the Cyber Resilience Act. And I want to do this in the form of 10, or let's see how many it is, of 10 examples, just very simple examples, but to show you different aspects regarding the Cyber Resilience Act in, I hope, a very vivid way. So let's just dive right into it. We have a legal supply chain, because with all the examples, I want to have a focus on the chain of a product, of the supply chain, up to the suppliers and down to the customers and distributors. So this is a usual setup, very simple. Manufacturer M is having a product, for example, the cooking machine. Different parts go into it. There is a supplier C, it's a sole. They're having a single, very simple product, obviously. Or apparently there is no additional supplier. Here you have a supplier B, which has a supplier A before it. So this is a more complex chain of supply. And then you have the other direction. You have an importer, maybe, if you're abroad and you're importing it to the EU. Then you have a distributor, and then you have a customer. And this customer may be business to business, or B2C. The Cyber Resilience Act doesn't care. It's in the end the customer. So this is a basic setup for all the examples that we go through. And again, the Product Liability Directive, as I've just said, the Cyber Resilience Act does not include any regulation on the legal liability. And there's just obligations, and of course, if you violate obligations, then you're opening yourself up for liability. But how this liability works is currently still regulated on an EU level in the Product Liability Directive, which is from 1985. Actually, it's very old. Software is never mentioned there. Windows 3.11 was 1993, I think. So this is way before a lot of things regarding software. So there is time and there's a necessity for a new Product Liability Directive, which is being worked on in parallel, more or less, to the Cyber Resilience Act. There's been a draft adopted in March of this year. And what I want to point out here is that they actually say in the Product Liability Directive that commercial enterprises should conclude contractual agreements to limit the liability in the supply chain. And this is done already, and this should be done in the future, but it's not done for you in the Product Liability Directive. But it's a good thing to like have this in your contract. Look at your contract, look at the obligations that you have in there, and limiting your liability downstream and upstream. You want to uphold the liability. You want to say, well, you're still liable, for example, extending the statute of limitation or anything. So even the EU Commission and even the EU gives you this hint of changing and having a good contracts here as well. So example case 0, I myself always have liked to program in C, the most security vulnerable buffer overflow language there is, but C is 0 based, so I have a case 0 here. And let's go into these. Quick example, importer I is an import, and he imports he imports a machine type manufactured by M in the USA to Germany and other EU countries. With the help of the importer, manufacturer M does a conformity assessment and affixes CE marking. Usually M sends the security updates, they send it over the air. And there is a bit of an issue here right now. There is one vulnerability that M in the USA considers more of a feature than a vulnerability and says, nope, I won't give you any feature update here or any security fix because it's a feature, not a bug. On the other hand, all the authorities in the EU beg to differ, and I get somewhat, the importer gets somewhat nervous. The question here is like, what should the importer have done and what does he have to do now? Well, the importer here in the EU has to adhere to, obviously, EU law and to what the EU authorities ask from him. So if they say there is a security flaw and he can't challenge this in a court of law, then there should better be a security update. So what should he have done? He should have done a better contract with the manufacturer M, actually saying that if he thinks there needs to be a security update, M should provide it, or if M still doesn't provide it, that the importer can exit the contract in a orderly fashion, maybe even ask for damages because the manufacturer didn't supply these changes. So there need to be more thought into this whole setup between manufacturer and importer into the EU if the manufacturer is located outside of the of Europe. Further example case 1. Manufacturer M is a manufacturer of a very old machine type, let's just call it XC2000, which is widely used by customers in their production lines. It includes software still written in COBOL. M does not see any feasible option to do a conformity assessment under the Cyber Resilience Act for the old machine. As you well know, COBOL, the technicians and programmers with knowledge for the very old machine are not very available anymore, and it wouldn't make sense economically to update all this. However, M has entered into long-term service agreements with customers, for example, 10-year contract terms still running. At the production side of customer C, a wear part of the XC2000 broke down. C is asking for a replacement part. That replacement part itself would fall under the scope of this Cyber Resilience Act. And now M has a question, does he have to terminate the service agreement and pay damages because he's violating the 10-year contract time, or what can he do? So again, the simple setup is you have a machine out there still being used, and you don't really want to update it and make it declare conformity to the Cyber Resilience Act. but it's still out there, it's still in use, and that's okay. But now a customer asks for a wear part replacement. Can you provide the replacement part? So there is a particular clause in the Cyber Resilience Act to the effect that spare parts can still be delivered and manufactured under the Cyber Resilience Act if without having a CE marking affixed to it or having any change made to them, if they replace identical components and they're manufactured to the exact same specifications. You have to have a replica of the old spare parts. It's not allowed that you can make changes to these. But good thing here is that you can deliver these that you can deliver spare parts if they go if they malfunction, for example. Example case 2. The manufacturer is still producing the XC2000 machine and is actively selling it. It has not been substantially modified since 20 years. It's his best product. It's feature complete. It's still being used. Maybe 20 years is a long time frame, but let's just say very long here. M is still unwilling to do a conformity assessment under the Cyber Resilience Act. M is wondering if they have to discontinue the Cyber Resilience Act if the Cyber Resilience Act comes into force and fully applies, which is in 3 years. So a very fundamental question. You have a legacy product, you have an old product. It's like a product which is proven by time. It's been used since 20 years. It's a good product, doesn't malfunction a lot. You can give spare parts, as we just learned, into the market, but he wants to sell new ones in a couple of years when the Cyber Resilience Act fully applies. Can he do that? It's because it's an old machine. It's still there. It's not a new machine that he has manufactured newly, invented newly under the Cyber Resilience Act. Can he do that? And then I want to ask a case B, or give you a case B. Here we have a manufacturer number 2, and he has a software, a mere software for download, and he does not like the Cyber Resilience Act, this manufacturer. This manufacturer quickly releases a new software version for download, places it on this website for download 1 year before the Cyber Resilience Act fully applies. Does that work? Can he, like this way, circumvent the Cyber Resilience Act? So when answering this question, it's usually a very complex talk sometimes, depending on where you're coming from. If you're coming from a non-legal background, you have one view. If you're coming from a legal background, you're having a totally opposing view usually. And then in my personal view, there is some language in the Cyber Resilience Act which is not as clear as it could be. The main article here is Article 69, transitional provisions. And let's make it simple here. Let's just look at the subparagraph 2, which says products with digital elements that have been placed on the market here in probably 2027 shall be subject to the requirements of this regulation only if from that date those products are subject to substantial modifications. So again, if you have a product and you have placed it on the market before 2027, these products only are subject to the requirements of the Cyber Resilience Act if there are substantial modifications. Now, depending on where you're coming from, you might understand this very differently. And I think there's a lot of confusion. And again, I think the wording here and in other clauses is not the best as it could be to lead to clarity here. But if you're more from a non-legal background, you would say, well, the product is the XC2000 machine type, and it has been placed on the market for 20 years now, and no modifications are made. So this clause here probably applies. If you come from a more legal background, then you're saying, well, a product there are a lot of other regulations and directives out there. For example, the Product Liability Directive. If you look at the Product Liability Directive, you're liable for each instance of a product, like each single instance of an XC2000 machine, you're liable for that, not for the whole thing, the whole type of machine. So how you have to read this here, and how the EU Commission will read this, and all the authority will read this, is that the product being placed on the market is just a single instance of the machine. So all the machines that you have sold and put in the placed on the market before 2027, they still can be sold as used machines, or distributors can sell them. But if you place new machines in the market, let's just say in 2030, for example, and it's exact same machine type, manufactured by the exact same specifications, it's a new placement on the market here. And this fully has to adhere to the Cyber Resilience Act. This is how it will be read by the authorities at the moment. Again, I think this could be defined better here, but this is what the authorities will have here. So I'm going back to this slide here. In case A, he will have a problem because he cannot sell the machine here anymore if he doesn't have the new CE marking affixed to his now conformity assessed machine after the adoption, or after the Cyber Resilience Act fully applies, which will probably be late in 2027. On the other hand, there are some, let's just say, edge cases where this is not so clear, and this is just one of the many aspects why I wanted to tell you this. The language here could be way better, because let's look at this case B here. You have a case B where we had the manufacturer of a software for download, and there's a question: when do you actually place a software for download on the market? And it seems that the majority opinion is that the placing on the market happens when you upload it to the server and having it ready for download. And everything else is just like an unlimited amount of downloads or software produced, and you just can sell them later on. So there are many who say, if you, in my opinion, many who say that if you upload a software, having it there for download, it's placed on the market and you don't need to change it later on. Of course, if you change the software, put a new version up there, then it's a different scenario. But for the software case here, it's handled differently, and you already place it on the market, so you don't need to change the download link later on. This is just one of the many edge cases that I want to point out here. So I don't know if it's interesting to you. We can. I'm happy to talk about it in the Q&A. I think there are a lot of there's a lot of big impact here regarding these questions, and this is one of the. This is why I'm saying there could be more clarity, because many companies will have to decide if they discontinue some very old and proven products, because it doesn't make sense economically to make a conformity assessment, or it just cannot be done if it's an old COBOL machine. It makes more sense to just invent a new machine or a new generation of these machines. And in particular, this transition period of, in the end, just 3 years, if it comes into force as expected later this year, is, in my view, very, very, very short. Let's switch to example case 3. M released a new kind of cooking machine. M determined a support period of 10 years. Now we're fast forwarding to 2047. The cooking machines are not sold actively anymore. However, there's a noteworthy used cooking machine market. Can M just stop issuing security updates? So what's happening here? There is some new aspect which I haven't explained before. There's support period. What is that? The Cyber Resilience Act invents a new thing which you already know from your smartphones probably, and some other noteworthy software products, which say we're placing this new piece of software hardware on the market, and we're going to give you and provide you security updates for the next 5 years, for example. And the Cyber Resilience Act took that up and put that into the letter of the law. They put it in the Cyber Resilience Act and said, okay, everyone who's placing products with digital elements on the market now has to specify a support period, and for that support period provide security updates. It's not feature updates, but security updates. And you, as a manufacturer, are responsible for giving a, let's just say, good support period, which usually should be the expected lifetime of the product. So let's just say here it's 10 years. And this, first of all, also has a big economic impact, I think, because before you just sell a product or whatever, maybe you rent it, but let's just stay with selling. You sell a product, it needs to be adhered to all the regulations. It needs to be free of malfunctions and defects at the point of sale, and afterwards you maybe have a small phase from civil law for 3 years where you have to be liable for any defects, but afterwards it's done. And the one-time point of sale is a relevant point in time. And now this is extended regarding security updates for 10 years or whatever in the future. The standard is 5 years. It's kind of the minimum is 5 years, it says in the Cyber Resilience Act. Expected lifetime, or at least 5 years usually. Or if you go lower, you can lower, then you need to give a real good reason why it's just lower. And for this time frame, you have to provide security updates. And here in our example, we're outside the time frame for security updates, and I just want to point out here what the EU put into the Cyber Resilience Act. I think it's a nice idea, but a very unrealistic idea. They said it's, well, if the product reaches the end of their support period, the manufacturer should consider releasing the source code for the product to other undertakings, or make it publicly available so that everyone can patch and do vulnerability handling. And then they also recognize that there might be business secrets involved, and then as they said, well, you can make contractual agreements so that these business secrets are still kept kind of secret. I think this is a very interesting approach. It's very good from some point of view, but I think it's totally unrealistic. Nota bene, and as I want to point out here, this is just a recital. It's not a legal binding thing. It's not in the later articles, and even here it says you should consider, as it always does in a recital. But this is the idea. So if you have a product, it reaches end of life, it reaches the end of the support period that you have specified, then you could release it to the public or to some other manufacturer who is actually willing to still do the vulnerability handling. So I'm going over some further examples a bit more quickly here. Example case 4, M software is fully compliant with the Cyber Resilience Act. He has version 1.0, 2.0, and 3.0. M is spending a lot of money on issuing security updates for version 1.0, which is completely out of date feature-wise, because most of the customers upgraded to 3.0. Versions 1.0 and 2.0 are only used by very few customers in the end. M wonders if he can offer security updates to just version 3.0 and discontinue the prior versions. So this as well shows how complex, and you know better than me how complex it can get to have all the different pathways for a security update regarding the versions out there in the field. If you have like a customer with 1.0, he didn't upgrade to 1.1, but now he wants to upgrade and he's missing one in between. How do you do that? You have another feature there, and like there is a myriad of different ways for the security update to find its way, and which needs to adhere to the security update path, like in the version path, sorry. Anyways, there is an Article 10 subparagraph, Article 13 subparagraph 10, and it says where a manufacturer has placed subsequent substantially modified versions, so the 2.0 and 3.0 of a software product, only applies to software. That manufacturer may ensure compliance only for the version that the manufacturer placed on the market last. So this up until here is very good news. So this would mean the manufacturer only has to give security updates for 3.0. But here comes the big if, provided that the users of the version previous placed, provided that the users can use it with free of charge, no additional costs incurred. And these costs is not only for the software that you're supplying, but also that they don't need to adjust the hardware and software environment of theirs. So for example, if you're saying your 3.0 version all of a sudden needs double the RAM or different CPU because it needs more resources, then you would have to provide the customer with a new CPU in it, with more RAM, whatever, so that the requirements of the 3.0 version is being met. I think that's very unrealistic. You probably would choose to still provide security updates for the older versions. But the takeaway here is maybe to also make sure that the system requirements that you specify for new versions, maybe you don't want to go up too quickly anymore, because with this stipulation, you're cutting off the option to providing security updates only for the later versions. Next example case. Manufacturer M's machine is fully compliant. The product has a CE marking. The machine is a thermometer to check the continuous cooling of the product it is attached to from the production line to the point of sale. The product works by continuously recording the temperature every 10 seconds. At the point of sale, this record can be read via Bluetooth and be evaluated. So it's a very, I think a very good invention. You have a thermometer attached to products, for example, I don't know, could be meat, for example, and it's there continuously reads the and saves and stores the temperature. And at the point of sale, you can actually look at the history and say, okay, this piece of meat, this stock item has been always cooled at the right temperature. There's no lag, for example. There wasn't any gap. It didn't defrost or anything. So what's happening here? The thermometer is very cheap. It's just €1 per item. There are millions of products out there in the market by now. Someone finds a severe flaw in the Wi-Fi library that is also present in the thermometer. However, that library is not being used at all in the Wi-Fi hardware chip in the thermometer. All the other manufacturers with the products using the Wi-Fi library are updating their product because it's a huge flaw in the Wi-Fi library. For M, the cheapest option if he wants to do a security fix or update is to just issue new thermometers. It's just €1 sales price per item. But the huge cost is involved with just sending it to everywhere and replacing it everywhere. So this cost in the end, if it's not covered by insurance, M will go bankrupt in the end. So M wonders, does he really have to change it? Why? Because in his product, this faulty library is present, but it's not being used. It's just being used, there's Bluetooth chip and Bluetooth is being used to read it out, and there's a Wi-Fi library. He just didn't deinstall it in his Linux environment that he's using in there or whatever. And is it a security flaw or not? So there's an article 8, or making this quick, sorry. There's an article 3 defining a vulnerability, and this definition says a vulnerability means a weakness, susceptibility, or flaw of a product with digital elements that can be exploited by a cyber threat. And then you have a chain of definitions what a cyber threat is and up to the Cybersecurity Act. But in the end, here it says that can be exploited. You have to go down a little bit deeper, but in the end, I would say M could very well argue that the security flaw present in the Wi-Fi library, for him, it's not at least not a severe vulnerability, because it cannot be exploited in his instance. There is no way, there's no Wi-Fi chip present. No one can exploit this security vulnerability. If you read it and understand it this way, this means that not every issue and not every security alert or flaw that is being detected in some kind of library means that it's a security vulnerability for your product. You have to decide if the specific adaptation of this third-party library or third-party software in your application leads to a security flaw, a vulnerability in your product. This in the end is a good thing, because you have an additional layer where you can say, well, and this can go even deeper, because you could argue maybe that you have built a different safeguard, a different sandbox around your product, and that there is no way that this vulnerability will lead to a security that this can be exploited. For example, if you have a browser and you have a sandbox around the browser, then you could maybe argue that even if there's something exploited in the usual browser code, it can never go beyond the sandbox that you've built around it. You could think about doing these measures for your product as well, so that you're not as exposed to these third-party libraries and their security flaws. Example case number 6. You are a manufacturer M of standalone software S. S is written in the programming language C. Yay. S depends on a commercial third-party library L1 and many other libraries, of course. This L1 depends on a third-party library L1-1. So we have a chain of libraries and dependencies. L1-1 is a simple open source project implementing a communication protocol. L1 is stable and has long been feature complete. Updates are rarely needed, but whenever necessary, the sole programmer P released an update very quickly. Without much notice, P goes on a sabbatical and travels the world for a year. During P's absence, a critical security flaw is after all identified, and a white hat hacker who posts the exploit on a social media platform. 1 month later, the manufacturer releases a new version of his product, including the old, quote-unquote, old L1-1 library. So this, in the end, refers to the caricature, the small picture that you're probably all aware of, where you have a dependency system where, like, which libraries does your software depend? There are huge blocks, humongous pillar on the one side, and on the other side there's like a pen-wide single library. The whole thing depends on it, and if this library has a flaw, then the whole project tumbles and then falls. This is kind of the thing here. So the problem here is there is a very simple project, a simple library included, and M releases a new version after there has been an exploit made public. So there is an Annex 1, which you have to adhere to under the Cyber Resilience Act, with many different so-called essential requirements. And one of these requirements is that the product is to be made available on the market without known exploitable vulnerabilities. So what does this mean? You as a manufacturer have to make sure that all the libraries that and all the third-party software that you include is free of any security flaw or fault or exploitable vulnerability. In my case that I just gave you, it wouldn't be enough to watch the changelog of the project or to watch their official website for any updates on security flaws being identified. Here you would also have to see what is known about this project. First of all, you probably should be aware that it's a single guy, a single person project, and this is that you have to have a very close look on this project. So just knowing there is no update for a while should also make you maybe nervous, although it's feature complete here. But for this scenario here, the manufacturer M would have to have a different quality management system or a different system in place here, so that they actually watch what is publicly known about this library as well, not just watch their change logs. So these are some further aspects regarding the new obligations here, because if you don't, you're opening up for liability. Just because you released a new version, not even changing the L1-1 library, but just releasing a new version with a security flaw, while that security flaw is publicly known. Looking at the time, I will do one more case, and not to hinder any Q&A here. Example case 7. Every manufacturer has to draw up a technical documentation for their software. Manufacturer M's software is written in Java. S includes 10 rather critical paid third-party libraries. What does M's technical documentation need to include? This is just to make you aware of this fact here, that the technical documentation is there. If you're familiar with the conformity assessment from maybe other areas like medical devices, for example, or cars or what have you, then you know that the technical documentation sometimes can be more complex to draw up. But also there are some requirements under the Cyber Resilience Act that you have to have a single technical documentation. Meaning that it's not enough sometimes to have a technical documentation for your product in the sense of the product that you programmed or assembled yourself, but also a technical documentation which includes aspects or the technical documentation of all the supplying software and hardware in there. So in some instances, you have to have access to the technical documentations of all the other parties. This, in the end, is something that you might want to consider also in your supply chain and also in the supply chain agreements, because you need to do this now and put language in there that your supplier is actually responsible for drawing up a technical documentation to make it as compliant to the EU as possible, if you don't do that, and to give you access to the technical documentation as well. Looking at the time, I will close here, but include some of the further aspects. Regarding these agreements, you should also have some further stipulations in there. For example, there will be notified bodies for some products in higher classes, in higher risk classes, and they will have to make unannounced visits and will look at the products, which are actually how they're assembled, or at the technical documentation there, like on-site visits. And this sometimes can mean that they should have access to third parties and suppliers as well. So you want to make sure that in the language, in the contract with your suppliers, that they actually have to let them in and help make the audit go as smoothly as possible. There will also be coordinated sweeps by authorities, and for these as well, you might want to have language included, which to the effect that your suppliers also have to help make these sweeps go without finding on your side. So I'm a bit over time, so thank you for that, and I think everything else in the Q&A. Thank you very much, and looking forward to the questions.
Okay, so thank you very much. I was actually also in Munich, and unfortunately I needed to moderate one of the other sessions there, so I didn't get a chance to listen to your sessions. So I'm very happy that I now had the chance to listen to it. Very interesting. So thanks a lot for doing that again. And I will actually just pull out one comment, which was just sent from the audience instead of I give my thanks to you. There was a person who just stated, not a question, just being thankful. It was wonderful to get the requirements explained with all those great examples. So you hear, the audience very much appreciated what you did, taking the time to explain that to us. Thanks a lot. That also is very helpful for all the developers and engineers out there.
Thank you very much.
Okay, so with this, I want to move on to the actual questions, so Q&A, and some of them are kind of repeating. So if I don't raise your question exactly the way that you worded it, you know that I basically combined some questions together because they're just fitting together quite well. I will run through it in the opposite direction, just because I think that the latest examples are just are still in the back of the minds, right? And they don't need to think about it too much. And if you want to switch back to some of your slides, Gerrit, please feel free, do whatever you need to explain it. We just want to make the best out of the chance that we have here, raising those questions to you. Okay, so let's get started with actually a question just about your example case number 6. And there are multiple questions about that. What does publicly known mean? Obviously, a manufacturer, a company cannot observe all the different security or cybersecurity forums or social medias out there. It's just impossible. So what is publicly known?
I cannot give you more clarity than there is in there. So I can give you my opinion, but it's important to know that it's now going more in the opinion phase. And we still have the draft here. And we do not even have the full document. There are still blanks and spaces in there. And the way law works is that you have a majority opinion in the end, and then you can kind of say, well, we follow that majority opinion. In the end, what is publicly known? If you have whatever, if you ask 2 colleagues, where would you look? And you haven't looked in these places, then you haven't looked where it's publicly known. If you ask the 100th and only he comes up with a new source, why didn't you look at www. whatever? Then maybe it's okay if you didn't look there. So this is kind of the way I would describe it in very simple terms, if that makes sense. So if it's obvious and you didn't look there, then you have a problem. If you didn't look at the most remote place, then it's okay, because no one expects you to look at the whole internet, that you scan the whole internet all the time. I also expect a time goes by and this gets more implemented, there will be more and more helpers out there, and the security flaw libraries, there will be more databases. I get they will maybe scan for you, and then you will look at these meta databases. They're already out there, some meta databases there. Then I think you will get the help there. So it's a changing target in the end. So two answers, I guess. First, asked 2 or 3 colleagues where would they look, and there you should have looked. And later on, I think there will be more and more helpers with meta databases and things like that.
And I guess about the frequency on how often you need to check those resources, there's also no real guidance. It's just check it.
Yeah. Yeah, actually, as this is a typical legal answer, it depends. But here I drafted the example in a way where it's a single person project. And you should have identified this as part of your conformity assessment and all the other work that you have to do as well. Like, is this a project run by a lot of people? And if someone goes on vacation or sabbatical, not a problem, because someone else will take over, no one will really notice. You should know that you have there in your project a more or less critical, what's not critical in security, but you have a project in there with just a single person there. And for that, you will have to have a very close look, and you should have a closer look on that. And you have to, if you have a monitoring system, I think you should monitor, regarding the frequency, monitor the bigger projects, maybe let's just say less frequently as the single person project, because you have to closer look there. Maybe it's not even enough to just monitor. Maybe you have to actually talk to him, and looking at the changing ecosystem there, you probably have to go and see how you can help him maintain everything there. And the hopes are that you might even pay him, and then if you pay him back, then there will also be some kind of agreement maybe, and then you could also have an stipulation in there that he actually notifies you of anything that he becomes aware of. Because if someone knows, he knows, and maybe if he goes on a sabbatical, he will inform you. This can be very good idea depending on your product. If you just pay him X amount of money per month, he will be happy maybe, not a lot of money for you, but you also, regarding your liability, have a contract saying, well, he should inform you for this and that. And this will also help with your liability. You have to make sure that it's still open source software, but I think we have other questions.
Yeah, plenty. Around the same time, so I'm not sure, I would assume it was around example case number 5. There you said something about the requirement of the product being free of security vulnerabilities. And the question here was, does this account, again, every instance that it is brought to the market, or is that considering the product when it's developed and built?
This, I have to think about this. I have taken for easiness sake here the annex with the essential requirements. The essential requirements is something that you have to meet regarding the product, and the way this works is actually counter to what software development usually looks like, where you just have a piece of software, you put it out there, and then you have a bug tracking system, and the main bug is software not working yet, and then you go from there. This is how software development sometimes is done today. It's not DevSecOps as it should be, but in the end, this is more kind of the way it works right now. And quite opposite to this is how software development is looked at in this regulatory framework. The best case scenario here is you have a software, it's feature complete, and you put it on the market, and then you don't change it anymore. Then you just have security updates here and there if necessary at all. So the best case scenario here is that you have the finished, polished product and do the conformity assessment on that product, and then there are no changes anyway, and the question just doesn't arise. This is more or less the way the lawmaker looks at the product. I know that's not reality. That's not how it works there. But you also have to be aware that every time you change your product in a fundamental way, it's actually kind of a new product, and you have to redo all the essential requirements here and redeclare conformity. You can make small adjustments, you have security updates, but if all of a sudden you say, well, it's more of a kind of a new product, then it's a new product and you have to redo all this, and this needs to be done at least at this point in time.
Okay, so what I'm getting from that is that if I have my software available as a download and I get aware of a vulnerability via a CVE or something, I don't need to immediately block the downloads until the CVE is fixed or the vulnerability is fixed, and then I can start the download again with the new version. I can keep it up.
Not really. There is something else more sinister in there, which there are many things in there, but there is a 24-hour notice period, for example. If you become aware of a security flaw, you have to give notice within 24 hours and start working. And this also applies on Friday evening at 5 p.m. and the clock is ticking 24 hours. And then you have to give an update at least immediately at least 24 hours. And then you have to give an update after 27 hours. And in this loop, there is the Market Surveillance Authority also involved. And they will tell you what to do depending on the severity of the security flaw. So this question will not arise that if you need to block it or not. You will have everyone on board on Friday evening and working on this because you have this additional requirement. So in the end, this is more important and you will find out everything there. So depending on the severity, you might want to block it. But in the end, the products are already out there and you have to think and consider what with the products in the market, do you even need to recall them, depending on the severity. But the surveillance authorities will probably have their opinion as well.
Okay. Then another thing, following into the same area, is the expected lifetime that you mentioned. So you said that for the expected lifetime, the updates need to be, or security patches need to be provided. Now, what is the expected lifetime for a software? Because software can run forever.
You shouldn't. I wouldn't put this in your documents because then you have a very long support period. Yeah, I think this will be one of the a lot of. This is something that will be talked about a lot, I guess. There is some hints here and there in the Cyber Resilience Act itself. There will be some guidance by the EU. They will, for example, look at the market, what all the competitors are doing. And if they give a 10-year support period and you just say, well, it's 2.5, for example, they will say, well, something looks odd here. Or you know this beforehand and you can also already orient yourself on what everyone else is doing. And there will be documents later on, hopefully in time, by the EU saying, usually if you have these components, usually if you have these products, it's a lifetime or an expected lifetime of X. And there is a lot of documents with more fuzzy language saying and some ideas how you can calculate the support period. But in the end, it's still kind of you have to kind of take an educated guess, but there will be guidance. Okay.
Then there was a question about the term of substantial change. What does this mean for software products? Does the definition apply to firmware or BIOS updates or operating systems as well?
It doesn't matter where it happens. You have to look at your product as a whole. And if it substantially changes, that's relevant. It doesn't matter where this happens. And the question, of course, is what's the substantial change? There is no clear and definite answer to this. There are some hints here and there in the Cyber Resilience Act. In the end, what definitely is a change if the intended use of the product changes. If you have put it in the market as a password manager, for example, or as a editor, let's just say, and all of a sudden, and you have some cryptography in there, and all of a sudden you find out it's more of a password manager, and you're going more and more in the direction of a password manager, then you have changed the intended use of the product. And this is then beyond this threshold and you have a new product. Of course, there's lots and lots beyond this threshold, and there is no clear line where you say, okay, if you change X amounts of lines of code or anything that constitutes a change product or a substantial change, you have to make an educated guess here as well. There is some guidance, there will be some more guidance on this, but there never will be a very clear distinction on where the line is being crossed. You have to make a decision maybe based on how careful you are. Maybe you're saying this is a new product, just to be careful and do the conformity assessment again, or fix the new CE marking again, because you know there will be updates as well. But there is no clear line. There will be more and more guidance though.
Okay, then pretty much a similar thing, but so for your example case number 1, what happens if that was the example with the replacement, right? So
yep.
Having a direct replacement does not mean that you need to do the CRA for it or follow the CRA for it. But the question here is, what happens if the replacement is based on new hardware, since the old hardware is not available anymore? So that some things like the operating system or firmwares are different than from the original device. Is that making a difference, or is it still considered a replacement because it has the same task for the old machine?
I would have to look more at the recitals maybe, but in my opinion, this violates the stipulation number 1 here, where it says replace with identical components with the same specifications. And this would make sense because you're introducing new risks. It's okay, according to the Cyber Resilience Act, if you just exchange this exact same spare part. It is as before, it's just a new one. Now, if you have a new operating system or anything else changed, you're introducing new risks because, as we know, just one tiny thing different can lead to a huge vulnerability, and usually does. It's just usually one tiny piece. So a quick answer is I wouldn't consider this a spare part at the moment.
Okay.
It should be the same specifications, same software. Maybe maybe we can talk if a minor subversion changes, and it's just I don't know, they fix the language typo in somewhere. Then we can maybe talk about if it's still the same. But if it's here beyond a very low threshold, I would say it's not the same specification anymore.
Okay. Then if you just move one slide ahead, where you have like your graphic with the boxes, well, actually, then it's a few more slides with the example case number 1. So backward, it is about the suppliers and the manufacturers. So when you think that everything goes downstream, right? That means everybody or somebody who brought a component to the market also brought that was their product that they brought to the market. So they need to follow the CRA. Now, another company is using that component, so they also need to follow the CRA, but their supplier, again, also needed to do that already. Is there anything that, as a manufacturer at the end, as somebody who assembles something based on different components, needs to do to verify that their suppliers meet the CRA? Or can they just trust that because the product is on the European market, can they just trust that the supplied product is fine?
Well, it depends on the whole idea of the Cyber Resilience Act is that you don't delegate responsibility anymore, because that's what we're doing right now. Right now, you're having a contract with your supplier saying, dear supplier, you're responsible for everything. I want to have a safe product. You're supplying me with the product, make it safe. Otherwise, you're liable. That's what we're doing right now. And it works from a liability perspective, maybe, but it doesn't work from a safe product standpoint. If you want to have everything up and running with cyber attacks out there, the product itself needs to be safe. So the responsibility is shifted to you as a manufacturer. You are responsible for the whole thing. If you want to have cost reimbursement later on, okay, but you have to make sure that everything is safe yourself. And if I understand the question correctly, is how much trust can you put in what your supplier actually what he tells you is okay. If he says, well, it's cyber resilient ready, can you trust that? The question is, what does he actually give you? Does he give you a product with the CE marking according to the Cyber Resilience Act? Does he just say, yeah, well, I heard about the Cyber Resilience Act, it's fine? Or is there a security attestation, for example, in place, like the ones I showed you regarding the open source software? There are similar things for other things. Does he have some harmonized standards observed and things like that? So you really have to make a distinction what he does there. And depending on, I would say, credibility of that company, size of that company, I think you can sometimes take his word for it a bit, but in the end, you are the one responsible. And the question is like, how much risk are you willing to take? If you say CE marking affixed on it, I am sure everything is fine, because that's what you're declaring.
Okay. Quite interesting, also for me personally. Okay. Then there was a question about the product liability directive. And the question here was whether you can actually provide a link, or where can somebody find that product liability directive?
I would say in the upcoming UPC summit. No, just joking. Just Google it, Product Liability Directive 2024 maybe, then you will find the, with these terms, then you will find the current draft. The EU sites could be better, I think, giving information and making it so that you can find it more easily. But if you Google a bit, you can find it with these terms. Product Liability Directive. There's a version of 2023 March that I referred to. Maybe later on I can give you the link with the slides, but otherwise Googling it would actually lead to the result, I think.
Okay, and then because we are already talking about those directives and things, there was another question whether for everything that you explained, whether you have also looked at the, no, I just need to find it again, corrigenda from July 27th, or is that based on an earlier version?
What I've said here, these things here is based on the June version. Actually, the corrigenda is semi-official, as I'm aware here. But there have been some corrigenda changes, which will hopefully lead to the EU Parliament not having to vote again on it. But this year, with the example cases, or if I quoted from it, it's the July version. Sorry, June version.
Perfect. Okay, so now
what was the question here is like there's the EU Parliament voted on it, and then usually the EU process says, well, here is a language correction or some corrigenda which are happening. This is happening right now, or at least happened, and depending on the severity of the changes, the EU Parliament has to vote again on it or not.
Okay.
That's very well.
So then there are still questions coming in. So now they come get a little bit out of order because now I haven't had a chance to sort them. So there's one question just to clarify again, the placed on the market. So the question is, so placed on the market means and is valid for every single instance of the product, not only for the first placement of the product. Just to clarify it again.
Yeah, I'm scrolling through to a slide where I have the definitions. So if you're interested in this a little bit more in the legal making, on the legal consideration, the placing on the market, yeah, the term is, I think, if you look at it from a natural language perspective, a bit misleading, but it usually is understood as a single instance of a product. And if you want to read up a bit more on it, there is a blue guide, and there is a definition or some ideas what a making available on the market is and what the distinction to placing it on the market is. And in both cases, it's a single instance of a product that is being placed on the market that's being looked at. Beware, the blue guide is not legally binding. That's interesting for me as a lawyer. So I have to actually look at what the Cyber Resilience Act says, and it's not that clear in there, but that's the usual understanding. It's kind of more or less factually binding for all the EU entities. So in the end, this will be the law for you in the end. So yep, it's the single instance. It's not the type of the product. It's very important if you're probably reading the Article 69 with the transitional periods. If you ask that question, I guess, but yeah, it's generally understood as the single instance.
Okay, then a question about the actual operators, the end users of products. Are there also obligations for the operators in the CRA, or is that purely in NIST 2?
Well, the operators don't really have, no, they don't have any noteworthy. I might have to look if there are some details here and there, but the operators, if they have a product, it's okay. It doesn't matter when you get the product. If you use it after 2027, it's okay. If you render services as an operator with this product, for example, if you just don't use it internally as a production machine, for example, or what have you, then I think I would have to think about it some more, because there is, for example, in the medical devices regulation, there it says if you render services with this product, then you still have to make sure that it somewhat complies. And this is all very similar from a regulation standpoint. It's all part of, I have it here, of the new legislative framework, and it's very similar there. So yes and no.
Then there was a question about the CE marking, whether the CE marking affects all software, or whether this is only for hardware products or medical devices and things like that.
In the end, it will be everything, software and hardware. The defining thing here is it's a product with digital elements, and you have to look for it in the Cyber Resilience Act. It needs to be need to translate this a networked product, so it doesn't need to be a very confined thing, like not attached to anything, but it needs to be a network product, which in the end, in our world today, is more or less anything. If you have a Bluetooth connection to anything, if you are a controller device, you're controlling some other, any OT device, if you're controlling any other product, it's a product falling under this. So it's not only hardware, it's also software, and software and hardware, and it's in the end most of the products out there.
Okay, then there was a question about the term of the known exploitable vulnerability. So what does this exactly mean? Does this mean that it can be actively, that the vulnerability is actively used, or does that all, yeah?
Well, I have the definitions here. I don't know if you're smarter, or if you know more after reading them, but this is the official language. So you have the vulnerability, which is of relevance. You have the exploitable vulnerability, which means a vulnerability that has the potential to be effectively used by an adversary under practical operational conditions. And then you have the actively exploited vulnerabilities. All the definitions play a substantial role in when you have to notify. Means a vulnerability for which there is a reliable evidence that a malicious actor has exploited it in a system without permission of the system owner. And then you have the cyber threat, which is further regulated. This is the legal text, and everything else is understanding this and going further down. But this is an exploitable vulnerability.
Okay, so the CRA actually differentiates an actively exploited vulnerability from an exploitable vulnerability. So the one is it's present in your product, the other one it's actively used. Okay, then there is a question about the availability of the CRA. So when will it be made available in the official journal?
Tell me, I would be interested very much. I still would personally hope that there made some clarifications in there. It doesn't look like it at the moment with the current corrigendum out there, but everyone expects it to be within maybe 1 or 2 months.
Okay.
And then it will there is two things. Then it will enter into force, I think 20 days after, so pretty much immediately. Entry into force doesn't mean much. Then then the date of when it will actually come into effect is irrelevant. And this is the Article 69, which we have been looking at. And then there is the transitional period of 3 years, and in 2 years there is some reporting obligations already. But within this year, it probably will be publicized in the official journal.
Okay, there's another pretty interesting question regarding the requirement of providing security updates and patches. If my machine lives for more than 20 years, can I make security patches cost money after the minimum of 5 years requirement of the CRA?
Well, you're stipulating that there is a 5-year minimum requirement. You have to specify a support period which is realistic ex ante for your product. So let's just make a case that you have a product and you're saying it's probably 5 years for this machine, like the kind of maybe the standard. And then all of a sudden you find out it's still in use after 20 years, so long after your expected support period. So then it's end of support period for you. And then the example which I gave you where after the support period, you should consider releasing your source code or whatever to a third party so that they can actually do the security handling. But then you're out of the water, then you don't have to give support anymore.
Okay, and another question about...
Save any considerations that because your question sounded a bit like it, where you say, well, actually it's a longer support period, and I'm just saying 5 year. So if you're really saying like just 1 year, but it's realistically way longer, then this might be different because you kind of cheated on your support period. But if you have a realistic support period of 5 and it's still being used by a customer after 20, then that applies what I just said.
Okay. Then another question about the security patches, and that is, we are always discussing that you can supply an update. Now, in his question, what happens if the hardware has a vulnerability and you cannot fix it or patch it by software? Do you need to supply new hardware?
Yeah, it's a good question. There's some language around this. I think one of the known examples are the CPU units recently. They have a hardware flaw in the end, very security relevant, and see how this is being fixed. The CPU units are not being replaced, but there are updates on the software trying to mitigate these problems. So in the end, there might always be the option of hopefully to mitigate at least the hardware problems by software.
Okay, and if you can't, then you need to distribute new hardware.
I actually would look into the exact wording here. There is some language around if you can't and what you need to do then. I can give the answer later on.
Okay. Then there was now I need to read a few questions real quick. Give me a second. So you mentioned something about the technical documentation for everything. Is there a requirement to follow a certain ISO or IEEE standard for doing the technical documentation?
No, this is not the way it works. Sadly, I know as a technical from a technical standpoint, you're living in the ISO norms and other norms, but here you have the legal text. The legal text is relevant, and then you have harmonized standards usually, which if you observe them, then there is some suggestion that you will be in conformity if you observe the ISO norms or whatever harmonized norms you have, like EN norms in the end. These will help you, but they have to be harmonized norms, and they're not there yet for the technical documentation, as I'm aware of. But they're working on this after the Cyber Resilience Act coming into effect. They will work on harmonized standards and more guidance and everything, so that you can more and more easily comply to the Cyber Resilience Act. Unfortunately, looking at other similar regulations, this didn't always work out pretty well, because the 3 years time frame is not that long. You need to start right now. If the EU just starts now, starting a harmonization process, I don't expect them to be finished in 2 months' time when you need the harmonized standard or anything. So I think things will change. The first instance of your technical documentation will be probably more according to what the Cyber Resilience Act and the annexes will tell you, and later on maybe you will have more technical guidances, and I will expect they will look a bit different. There's also the stipulation that the I think for the technical documentation as well, that there should be a draft framework by the EU, so that you have at least kind of the headlines on headline and now fill it out. So there should be guidance on that as well. I hope this will come in time.
So then there is a question about the liability. So who will, the question is a little, I need to revert it slightly. So who will anklagen? I don't know the English word for that, but
sue you.
Yeah,
Sue
exactly.
you.
So who will sue you when you don't follow the CRA? Is it like with the GDPR that somebody who is affected by it needs to sue you? Is it a market observation agency from national bodies? Can anybody do it who notices that you don't follow the CRA?
Well, I will understand the question a bit broader. What can happen if you don't comply? This is the usual question which every company should ask regarding or in consideration of all the different regulations that we have. I mean, the Cyber Resilience Act is not everything. You have the NIS2 directive here, you have the AI Act here, you have the GDPR and everything else as well. So there's a lot of things to do, and you have to kind of prioritize. And of course, what you want to know is like, what happens if I don't comply? So if you don't comply, one of the things is that there can be a fine by the market authorities, just like within the GDPR, where you have it in the press. Sometimes there it's up to 15 million, or I think 2.5% of your worldwide revenue. So there can be a huge fine, depending on your company size. This will be affixed, and this should be a fine which will make you feel it. That's kind of the idea behind it. If you ask really for who can sue you, this regards civil action, like in a court of civil law. Then the market authority, usually they don't sue you in the court of civil law. They just give you, they tell you what to do, and then maybe you can sue that it's illegal what they request from you to do. Suing you could be competitors, usually, saying, I spend a lot of money being in full compliance with the Cyber Resilience Act. I didn't like it either, but I did it. And now there is an actor who doesn't comply to this at all. He has a competitive edge because he could put all his resources and time and energy and money into his product development and not being compliant. So they could sue you, for example, for cease and desist and damages. So, well, depends if the competitor really is allowed to cease your damages, but he can sue you for cease and desist, and this can be quite damaging as well, because then you would have to, from today to tomorrow, you will have to cease having these products in the market, and you will have to take them off the market maybe. Sometimes for similar in similar situations, we do this for our clients, and then you of course look for the best place where you can do this. These are sometimes at fairs where you can publicly have a very public manner here, and this can be very damaging as well to PR and marketing.
Okay, interesting. Then there is a question, so jumping back to right at the beginning of your presentations about open source software. My company provides an open source software on GitHub. It also sells some maintenance packages on the software. Do you confirm we fall under the CRA due to this later activity?
Yeah, can you say the last part again? They do what for the updates support for, or what is it exactly that they do?
They sell maintenance packages for the open source software.
What would that be exactly? Let's just say there is.
I guess it's about implementing additional features. So like a feature request, and then you pay them to that it actually gets integrated, something like that potentially.
Would make sense. I mean, if you have something on GitHub and you find out that there's something that you need to fix, then you would fix it on GitHub as well. So maintenance needs something different. If maintenance is, as you just described it's an individual software programming, then I would say it's two different pair of shoes. Then you have your open source library, and then you just happen to be the same actor who's programming something in addition to that open source library. The case that as you described it with the maintenance package could be phrased differently. There's an open source package out there. You're using the open source package. An employee of your company or an outside company is adding to that software and adding features or whatever. Then of course you still have the open source software part, but you're also having new software for your own. Then you're having the open source part with everything here open source, and you're having your own software. In the end, it doesn't matter much because that company would have to do the full CE marking. The question is asked from the opposite direction, like does the open source software company or project have to adhere to the Cyber Resilience Act? I would say no to the GitHub project in this setting. For the individual programming, yeah, although it's individual programmed here, and we have to ask if this is even released to the general public. There are some lighter regulations if it's like individual programming.
So from if I just spin that idea a little, because I know that company, so I think I have an idea on what they're doing and how they're doing it. So when they would be asked to implement a feature, they would be implementing it they would give the resulting software to the contractor. So in that case, this software would need to follow the CRA. But at the same time, they can push those changes back to the GitHub open source project, in which case they would just be a contributor to that open source project, and the open source project would not need to fulfill the CRA. Is that correct?
I would say so, yeah, because in the first instance where they kind of sell the whole project, it's in the course of commercial activity.
Yeah.
And in the latter case, where they provide it to the open source community, it's not in the course of commercial activity. Of course, your task will be to really make it very crystal clear that this is to be differentiated. I also am not sure if there is a different layer in here where you have the open source project, because in your example, you've programmed first and then gave it back to the open source project. Maybe it would have been better to program first, give it to the open source project, and then use the open source project. So I think a lot of details factor and play into that, but I think you can differentiate. And the initial question was, I feel like, does it infect me doing something commercially? Does it infect my open source project? And I think you can make a clear distinction. If you make it very clear that these are two different things, then you can uphold this distinction and use the open source software regulations and stipulations there, and the commercial activity on the other side.
Okay, so I hope this answers their question. To me, it works to make sense.
No more clarity what the maintenance packages is, and I think we need to do the dialogue here to be more clear what the actual question is, because I'm sure the question wasn't phrased very like we have questions about the question.
Yeah, exactly. So then there was another question about some security implications. So assume that you have a product which on purpose has issues. So for example, it is intended to never be brought or connected to the internet. So it uses unsecure communication, like an unsecure protocol. Is that considered a vulnerability and by the CRA, and it cannot be brought to the market that way? Or they would need to fix anything to make it secure, or they wouldn't need to make it secure? Or is it okay if it's conceptual? open?
This question sounds very familiar. In the end, it's some kind of testing software that you're describing, right?
No, in this case, I'm not talking about our testing software from the OPC Foundation. This time, it's really a question from the audience. But they have a similar thing. I think that they are using something like a protocol for data exchange or for controlling, which has no security. And therefore, anybody who is at that network layer could connect to it and do something. But the intention is that this is like internal to the product, and nobody actually connects via this port. At least that is how I understand it.
Yeah, but the question that we have to answer then is there a security flaw? That's what the question boils down to, I think.
Yeah.
And then we have to go into I mean, we have here a question between what's the intended purpose of this software, and is the intended purpose a security flaw in the end? That's what the question is. Again, I'm looking at the slides for the definitions of the security flaw, vulnerabilities. We have them here. Does it adhere to the 41 under practical operational conditions? Because I'm coming back to my testing software question. I mean, we're not trying to use this piece of software in a operational environment.
I think they do. They do.
Okay.
So
for the purpose of?
I don't know, like condition monitoring of the machine maybe, or controlling something like a robot arm.
But if you, I think there is a deeper layer to this question that I'm not getting right now, and maybe this is something we can do in a dialogue. But in the end, if you have a software out there, which in the end is just like make it easy language, it's not state of the art because it doesn't adhere to basic authentication protocols, whatever, then why is that software out there? Let's be clear about that first. I would understand if it's a testing software, for example, where you would try to find out, does some system make an alarm, send an alarm that there is such a software out there. Otherwise, what's the purpose of this? And if you have this in a real world practical environment where it's actual operational technology and OT technology, and it's not being closely monitored, I would need to understand why you want to have this out there. But I think this is something more for a dialogue where I have feedback on these questions.
So I'll give it one more try with one detail. Assuming that you have a machine which is closed from the and the external connection is fine, but the internal communication is insecure. And in order to get to the internal communication, you would need to open the cache, go get somewhere inside, plug yourself in somewhere, and then you would actually be part of the insecure communication. Would you consider that a security vulnerability, or is that rather because it's in a closed product, it should be fine?
I think it should be fine. A quick answer, depending on how big this machine is, but otherwise, everything. I don't think that everything can be authenticated within one machine. It reminds me a bit of my example actually here with the case 5 and the that I made here with the Wi-Fi library being present in this thermometer and having a security vulnerability, but it cannot be exploited from the outside in a real world scenario where you would expect this. It sounds more if you're expecting someone to enter your site, your production site, and physically make some changes. I think these are some other aspects outside the Cyber Resilience Act. This is something more like in the direction of the NIS2 directive, where you actually have to make sure that your site and your production and your processes are safe, and any changes during your production, for example, would be identified. But short answer, with this setup, I would say no.
Okay. And then we were still receiving questions, but at some point we need to stop, right? We cannot go on for the whole day. There is another question about actually Windows updates, basically. So assuming that you have an interface or a software product, or your product is running or using a Windows computer. So that is like just part of your product.
Windows 98.
How can, and your machine has the idea of, or your product has the idea of running for 20 years. Now, Microsoft does not provide you security updates for Windows for that period of time. So how is it expected that you can keep the product secure? Do you need to provide like a different hardware then at some point with updates to the operating system to keep it secure, or?
You are the manufacturer. You are responsible when setting and defining the support time for yourself. You have to take all this into consideration. When you know you're using a Windows version which will be end of life in 4 years, and you give a support time for 10 years, and you're going to have a problem. And you have to state this support time very clearly when selling and advertising this product. So if you're advertising a 10-year support time, although you can only cover 4 years, then you're having a different set of problems, and you're opening up yourself for liability and market surveillance authority measures. Of course, you could try to fix Windows yourself, but I don't think we have to talk about that. That's not possible in the end. So in the end, you would have to say your product has a support time of 4 years when you don't know that you can give an update or an OTA over-the-air update or anything. I mean, you could say 10 years. If you know after 4 years you can update to the new Windows version, it would work. You're sending an OTA, then you can do a 10-year support time. But if you say 4 years, you have to make it very clear. You have to state it. You have to advertise it. You have to give it in your documentation. And this will also affect the price in the end. And then there is this full circle self-regulation, because if you tell people you can only use it 4 years, they will pay you less than if you tell them 10 years. And then you have an incentive to maybe find a different solution for your problem here.
Okay, and I think the one thing that we also need to remind people about is that Microsoft with Windows also needs to follow the CRA, right? So they need to provide the support and the security patches for the lifetime of their product. So
exactly. But if you look at their certification, and their certification says 4 years, end of life, or 5 years, whatever, then, and you're giving more, then you have to have some kind of follow-up plan for this additional lifetime there.
Okay, perfect. Very important information for our audience, I'm pretty sure. Okay, so I will really knock it off here, because I think we already ran a little longer than we planned. And so thanks again, Gerrit, for providing all those great details and great insights. As I say, we just now are starting getting thank notes again, so that really helped our audience. So thanks for taking the time and answering all those questions.
Thank you for having me. Thank you very much.
Okay, and with this, I want to say thank you to the audience, and for raising all those questions. I want to say goodbye and have a great Tuesday. Thank you. Bye-bye.